And Harper, Mr. Matuska.
Present, Your Honor.
Okay, what are we going to do today? He's got 1, 2, 3, 4, 5, 5 cases. It says MTRP hearing. Is that what we're doing?
Yes.
Okay, then it appears as though Desmond Harper is the guest of honor. Let's bring Desmond Harper out and let's move on those. 1, 2. Looks like 2 cases that the defendant is on probation for, and then there are 3 new cases that have been filed. Really? I'm looking at, I only have 3. 5 total. 2 on probation and 3 new ones.
He's not very happy. He doesn't want to come out, and he doesn't want to speak to the attorney.
He didn't have a choice.
Okay, are we good?
Okay. I mean, we would never get anywhere if that was happening.
Good, John.
Okay, you're Desmond Harper, sir? Is that right? You're Desmond Harper? Okay, just, the defendant is going to, we'll put the defendant right there in the jury box. And Ryan, you can have a seat there. We're going to move forward without. The court will note this is Desmond Harper. 2 cases are motions to revoke probation in 23 F23-41343 and 23 CR 580. We will move forward on these motions to revoke probation. There are 3 new cases. Aggravated assault with a deadly weapon, unlawful possession of a firearm by a felon, and another aggravated assault. Those will be.
Notice how the court separates the old probation cases from the new charges. This is not just bureaucracy. Legally, it matters. The motions to revoke probation could result in penalties before these new aggravated assault and firearm cases even go to trial. It's a strategic move to ensure the system is not manipulated by someone like Harper.
Be placed on the trial docket. As far as the motions to revoke unadjudicated probation are concerned, what says the state in these 2 cases, which are 41343 and 23 CR 580?
Your Honor, the state has told the officers here to testify the actual complainants in that. The defendant has been contacting via his mother both of the complainants on numerous occasions, probably 30 or 40 between jail calls and kiosk messages.
So he's communicating when he's in the jail, but when he comes out here in the courtroom, he's going to stay on mute, which is the rules are built to work around that problem.
So here's a red flag. Harper has been contacting complainants from jail, trying to influence the case indirectly. Courts take this very seriously. Any attempt to intimidate witnesses can lead to additional charges or stricter custody. The judge is already planning workarounds to keep the courtroom safe and fair.
All that is admissible.
And he's asking them to essentially sign affidavits of non-prosecution and say that the weapon was there. The only reason I'm saying this is the complainants are not here. And I spoke with one of them, said she's scared, and she is not appearing. We're having a hard time getting her due to his communications through his mother.
Subpoena her, and I'll just order if
Here. Hey.
get him out of here. Get him out of here. We will work around it. You are inappropriate. You are inappropriate. Get orders. Obviously, he's abusive, obstructionist, and is attempting to manipulate the whole system by attempting to intimidate people. And we will do what we need to do. We'll have a hearing, leave him at the jail, do a Zoom, and then the people can be here, and so they don't have to be close to him because of fear from his obstructionist acts and his threats of reprisals or threatening behavior. And those people will be ordered to appear, get me a court order. And it's obvious that the defendants, every defendant like this, bullied their way through the system that they would control. And then the rule of law would not be applicable. The rules of law state these are matters to be heard and will be dealt with under the rules of evidence. And a defendant cannot take over the system by being rude and abusive. What are you saying, Mr. Matuska?
Your Honor, if I may, I did attempt to speak with my client this morning or just a minute ago, and he was not willing to communicate with me.
He's a grown up. He didn't have to talk to you. And there's not much we can really do when they want to obstruct and try to take over the proceedings, which is not allowed. But either he's going to be following the rules or he'll have to be put in a place where it's obvious he is aggressive and people cannot be in harm's way who are just trying to do their jobs under the rule of law.
Can we ask that he be ordered not to be able to use the phone except to talk to his attorney?
That's true. That will be ordered. He's not allowed to have any use of the phone privileges except for purposes of speaking to his lawyer. Thank you. That is only fair. What else?
Your Honor, do you want us to go ahead and start? Is there any?
Well, I mean, is anybody here?
Yes, Your Honor.
Oh, okay.
Detective Mindy Freeman.
Well, the defendant needs to be somehow
Some capacity,
present
yes,
in a capacity.
Yes, sir.
And if he's going to be abusive, then we'll just keep him over in the jail and
Okay. Yes, sir.
do Zoom.
You have to enter certain findings to move forward without whatever you do in that regard, Judge. I know you're familiar with that, but it's out of the ordinary, so I just wanted to bring that to your attention.
I think one of the holding cells has capabilities for them to hear what's happening. But I don't know what you mean.
He still needs to see. Bring Mr. Harper out again, please. We'll see what he wants to do. Otherwise, we'll just have to redo it and put him in, do it through the Zoom at the jail. Mr. Harper, we're going to begin these hearings and you have to follow the rules of behavior. Do you understand?
Watch this. Classic power play. Harper clearly struggles with control, thinking he can dictate the courtroom. The judge handles it perfectly. Firm but procedural. In legal terms, he's establishing contempt boundaries while preserving Harper's right to a hearing via Zoom. This is courtroom strategy at its core. Control the chaos without violating due process.
Can't interrupt.
I ain't broken no law. I ain't even guilty of
Are you
charge.
going to follow the
Probation for
rules?
years, Bill.
Are you going to follow the rules of behavior?
Nothing.
All right.
Motion for recusal of
All right.
another judge,
Then,
another courtroom. I'm not gonna sit up here and let you
all right,
just
here's what
give
we
me
will do.
20 years for nothing.
Here's what we will do. You don't get 20 years for nothing. You
Yes,
get
for
20
nothing.
years for
You
your
don't
life.
get 20 years.
This is a
later.
debate. That's enough. If you're not going to be polite and you're not going to follow the rules,
I'm not
then
gonna
we
get
will
polite
hold
to
the
my trying to
Zoom.
give me 20 years, man.
The
Let's
Zoom.
get these other guys out the way. I'm following the motion. I'm not gonna. I don't want you to be my judge.
Okay,
You
the
said
motion is
a
denied.
lawyer said me and lied and said I threatened him. I have a CEO that is willing to come down here and testify.
You'll be able.
Yes,
be
he's
able
willing
to
to
be
come down
heard.
here and testify that I did not threaten that lawyer.
We're going to do it this way. You will be held at the jail. We will bring you into the Zoom room. We will have the hearing. If you obstruct, we will mute. You'll be able to hear and see. But we're going to
I'm
have
still
a hearing.
following the motion.
You're-
You can't deny me to follow the motion for
It
refusal.
is. You
When
can't.
somebody just said I
You
threatened
can
him
file.
and you said up here and told me that I'm violent. So
Sir,
you telling me you got my life in your hands.
hey, you're
for
being
something
abusive
that
right
I ain't
now.
even got a trial.
You're
You gotta
being-
give me a trial. Where's my motion for discovery? Where's my
You know, if
motion
there
for
was a
discovery?
crime for
Did I pick
rudeness, if
my
there was a
jury?
crime for rudeness,
Man, listen, man, I don't
you'd be
care about none of
guilty
what
of
you
it.
talk about. I don't care
See,
about your courtroom.
I guess-
It's unlawful.
I know,
It's
that's
perverted to justice.
You don't care. That's right. You
I don't
don't
care about
We're
none of
gonna
that.
follow the rule.
What are you telling me right now? This is my
We're
life,
gonna have
not
a
yours.
hearing. We'll be in the Zoom.
Yeah.
You file a motion,
I'm following the motion.
it's
I
denied.
guarantee I'll get out of here.
It will be denied, and
You
we'll
know
still
what?
have the
You know
hearing.
what? I have NAACP and everybody up here.
Okay,
Yeah.
you're gonna
You
threaten
got a
everybody.
sex case, don't
You're
you?
gonna threaten
Don't you got? I'm
everybody.
not threatening. Don't you got a sex
You
case?
can't
Why are you a
threaten
judge? You're a rapist.
That's all.
Come on, let's go.
He's out of here.
Fuck
And
that.
you're
I ain't going to
vulgar,
none of that shit.
and you're vulgar.
This man is obviously someone who is used to being in control of his environment. And like all of us, we have to follow the rules. He doesn't like that. He obviously wants to be in absolute control. We will work around that. He will be placed in the jail, continue to place in the jail. We will have a hearing. We will go through Zoom, and he will be in the room or not, but we will move forward. The court, it's obvious, and it will be make all it was a shout fest by the defendant who wishes to control the proceedings and in an aggressive, demanding, threatening tone. He has sprayed abuse toward the rules of decorum as well as the rules of evidence and procedure. But a defendant is not allowed to be obstreperous to the proceedings and just be violently aggressive, and then that will mean that the proceedings cannot move forward. It will move forward. It's obvious that he is dangerous.
You can almost see the courtroom drama unfolding in slow motion. The judge compares Harper to a child throwing a temper tantrum, and it's more than metaphor. Legally, a defendant cannot disrupt proceedings to manipulate outcomes. This is a teaching moment. Even the most aggressive or controlling defendants must follow the rules, or they risk being muted, removed, or otherwise constrained.
And aggressive and threatening and wants to control the proceedings. Thus, it will be a hearing held through Zoom. He will stay at the jail and we will proceed that way. He can be quiet and polite, or he can be abusive. If he wants to be abusive, then he can be muted so that it does not interrupt the proceedings. But it's obvious he wants everything on his terms, like a child. It was just like a 4-year-old or 5-year-old having a temper tantrum, which has no place in the courtroom, and no way we can handle any proceedings if people acted like that. But we will move forward nonetheless, and we will have it that way in Zoom. I want to have this reset for a hearing in maybe next week,
We'll do that with news.
and
Yeah.
we'll alert you.
We can do two. I'll be in Milwaukee next week on federal training.
How about week after
Yes,
next?
sir.
All right. Mr. Matuska, go ahead as his defense attorney. What do you want to place into the record?
Only that I attempted communication with my client. He's not at this time wanting to communicate with me. I only know he wants to deny both allegations.
Okay. Well, thing is, by raising a childlike fit and shouting over everyone, it's obvious that nothing can be done. And that's why everybody gets a chance to be heard fairly, and the rules of procedure, criminal procedure, and the rules of evidence apply. But you can see why people like Mr. Harper, who control things, would turn this whole world into chaotic mess where nothing can be accomplished except on his terms. But we're going to move forward, and he may not like it, but that is not the test under law. I think every defendant up here is unhappy to be up here. I can't think of any of the defendants are enjoying their time in custody. So these people are given leeway to vent a little, but not control in a loud, angry, aggressive fashion. And that's not domestic tranquility as the Constitution states it should be. Establishing justice, ensuring domestic tranquility. All of those are part of the preamble of the Constitution, which Mr. Harper is abusing. All right, we will reset in 2 weeks and we'll move on this hearing on this motion to revoke probation. And I think he said something about a motion to recuse. That's denied.
Don't know the grounds for that.
I don't, well, the grounds seem to be, as he stated them, that things are not being conducted on his terms as he would like, which is.
Just to let the board know, I don't need kiosks for communications through electronic mediums. I go to the jail, so you can have to modify the order for me.
Okay, well, let's say that. What do you mean?
I'll visit the jail in person. I won't use any kiosks or emails.
Okay, thank you. All right. Anything else? We're
That's right.
in recess on that. What else do we have this afternoon?